Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host, with my good friend, special guest, or I'm going to say Russ here. Look out. The habit from how many times. Talk about going back years. He was, well, I'll share that. I know I can get off on tangents too. Jack McCann is with me today. Jack is with McCann and Hubbard over in Cool Springs. I've been working with Jack for, I think it's about 7 or 8 years now with clients and helping with estate planning matters, real estate. Jack does 529s. He can help, or not 529, I'm sorry. 1031 exchanges. Yep. He can help with that kind of thing as far as real estate, contracts, number of areas there that can be helpful, and it all kind of ties around quite nicely as far as estate planning issues you're going to deal with. Because if you're dealing with estate planning, right, one of the things you're going to be dealing with, of course, is real estate. That's part of most people's estate, and Jack can be, so it can be helpful in having someone that's got both of those expertises there. And Jack, one of the things we were talking about just before the break, we're getting into probate, and so here we've got 3 main reasons that you might want to avoid probate.
Yeah, so, I mean, the number one reason people worry about is publicity. No one wants anyone else to know what their net worth is and how it's comprised. So now probate isn't always going to disclose that. Again, it comes back to having a will. If you've got a will, in that will it can state what records are available to the court and which ones are not. But if you don't have a will, everything is subject to court review, which means it's all public record. So that's a big reason to have a will. But the truth is, when we've got people that are more famous, obviously we live in Music City, USA. We have a lot of country music artists, and music artists of all types. Movie stars live here now, and they want to avoid probate altogether. So for them, we do revocable trusts. But the other things that probate can do is it can drive up the cost sometimes, especially if it's intestate probate. Much more expensive to die without a will than to die with a will. And then, of course, the delays that can be caused by probate. We run into that. Unfortunately, the financial institutions, they are very careful, very cautious. They don't want anyone to ever be able to come back later on and say that they did something they shouldn't have done. So they go out of their way to make you over-document everything, and that causes delays. I'm running into that right now with a couple of companies that we've provided them everything that they ought to need, but they want it on their form, they want it signed by particular people and within a certain time frame, and it just slows the process down of getting those funds to the ultimate beneficiary.
And this is the other, so we're talking about, one of the things with probate, when we talk about, I'm going over some real basics here today. What is an estate? This is basically all the things that you own. Estate planning, this is where this comes into play. In my book, I talk about in chapter 7 is all on estate planning, and the different parts about wills and trusts and the differences there, and we're going to get into that a little bit as well. So with estate planning, think of it, one, it has 2 parts, basically that in which you're the things you're going to do during your lifetime, right, to provide for your family. These are things that if you became incapacitated, do you have, what kind of documents do you have to help provide for that type of an event? The loss of a spouse, what happens there for the surviving spouse? Those are kinds of things that also are dealt with in probate, in a good estate plan. So one of the things there, Jack, is let's see what we have here on our slides. We'll jump ahead, Marilena, to most common estate plans. And this has to do with basically the intestate, no will, with a will, or a trust.
Yeah, and well, I want to go back for just a second. So earlier in the show, we were talking about the coronavirus and the issues with the market. But that's a perfect example to talk about the fact that a complete estate plan deals not only with what happens when you die, but also what happens if you're incapacitated. So when we do a total estate plan, we're also doing powers of attorney for healthcare and finance. So for example, if you were quarantined and you couldn't get to the bank or handle your business, a good estate plan will have documents in place that will allow someone to manage your affairs for you. And of course, if you're truly incapacitated, you end up in a coma or something, then it's even more important to have someone designated to be in charge, because a will does not go into place or does not go into effect until you pass away. So you can have an executor named in a will, but as long as you're alive, even in a coma, they don't actually have any authority. So you need to have those powers of attorney for healthcare and finance.
And this is a good point. I mean, and powers of attorney are one of the big ones. So one, as Jack was talking about earlier, you've got, if you die and you don't have a will, that's the most expensive way to deal with estate planning. And guess what? If you don't set up your own plan, the state has one for you. It may not be the plan you want in terms of the division of assets. Do you think your surviving spouse wants to share all the money with the children right then? Or do you think you'd rather have that for the surviving spouse's care and welfare for their lifestyle throughout their lifetime before it goes on to the children? That's the way most of these plans work, right? I mean, if you want to make provisions, sometimes I have clients, for instance, that say, well, I'd like to give a little something. The couple together say, hey, if the first of us passes, let's make a gift. It's just kind of a nice little thing to do for the children. That's one option available, of course. The surviving spouse can, of course, do that as well, but if it's done in there, that's just a way to say, it's almost like it's coming from that deceased parent, all right? It's the way it feels, and that's kind of what they seek to do. But most, it's like, well, the surviving spouse can take care of things. If they want to provide for a grandkid's college, for instance, if they want to make some gifts to their children, they have the ability to do that. But first and foremost, we want to make sure that they're going to be okay. So for most of the couples that I work with, this is one of the things we're dealing with, Jack, is they want, first and foremost, it's like, well, if one of us predeceases, the survivor should be able to maintain, so we want to keep the assets. Intestate, that's not going to happen.
No, it's not. That's a good point. If you die intestate, people think that everything is going to go to their spouse automatically, but that's not the case. If you die without a will, it's going to get divided between your spouse and your children. And some kids are going to turn around and say, oh, I'm sure that he or she meant for my other parent to be taken care of. I'll help make sure that happens. But not all kids do that. Some kids are like, oh, no, it's mine. I'm not sharing.
And there are practical things to worry about too. What happens, let's say they inherit a retirement account. Okay, now how do they give, they wanted mom maybe to have that if dad predeceased, but what's the issue? Now they got tax issues. So all of a sudden you might generate, and if it's at their tax rate, maybe they're likely to be still working and making a lot more money. And maybe mom is on just on Social Security, maybe a pension, right? Limited income. Who's going to pay? Who's going to be in a higher bracket? So if you're taking money out, even if your goal is to give it to mom, you're going to have to pay more tax. And this is one of the unintended consequences, again, with poor planning, is usually the IRS ends up being one of the ones that benefits most from it.
Very true.
So another is, power of attorney. This is a big one, Jack. You were talking about comas or, people that have, periods of incapacity that in addition to, a trust can be very helpful as far as administration, but at the very least, someone should have powers of attorney.
Absolutely. At the very least, you need powers of attorney to take care of, if you're in an auto accident, if you have Alzheimer's, if you're quarantined. These are medical issues that interfere with the daily business of the individual, and the only way to properly manage that is with a power of attorney. When we use trust for estate planning, the trust is an awesome tool, works very well. It's a great management vehicle, but I like to be safe, and I always do powers of attorney at the same time.
Because it can be helpful. This is one of the things with trust is that it's as Jack said, it's a great administration tool, but it's dealing with the assets in the trust. Okay, so you still need a power of attorney, because what about dealing with little things like utilities? Right? About matters that are dealing with business matters outside trust, talking to the Social Security Administration as an example. Any number of other areas, a company plan, a 401k. How do you access those funds if you needed to, if you're without a power of attorney? Because those assets in any retirement account cannot be put in the trust. Okay, so it can't be administered by the trustee, so we still need that power of attorney to do that. Let's take a look. We've got a slide up for estate planning mistakes to avoid. Let's take a look at that one, Jack. And one, of course, the most obvious is having no plan at all.
Correct, yeah.
As you mentioned, intestate is, the potential there. And this is one of those areas, sometimes people think, well, I'll just put it in joint ownership. And this has other implications.
Yeah, so sometimes people think that if they go and put their child on the account, then that child can manage the account for the benefit of everyone. The problem is that child doesn't always do exactly what you wanted them to do, And technically, if they're a joint owner on that account, everything that's in that account becomes theirs. They're not obligated to share with anyone. But even if they do have the desire to share with everyone, they're the ones that are ending up paying any taxes that come from that. And so whether it's an IRA or a checking account or life insurance policy, you could be triggering a tax or a burden on that person that they wouldn't have had otherwise if you had a proper estate plan.
And one of the things that can happen also with joint ownership, and this is where someone sets up a will, I've seen this kind of thing happen in the past, where people come in and they said, you know, Dad set up a will, you know, had his will and he left it, you know, left me, you know, these things, you know, this money, and yet it had joint ownership, or it had a beneficiary designation, leaving it to us to the what might have been a second marriage, as an example, and basically unintentionally disinherited his children simply because he didn't know. He's thinking the will's going to take care of it, and he's thinking the joint ownership is maybe just, you know, while they're still together or while they're both alive, not realizing that those things are going to have precedence over, priority over that of the will. So that's another. This one about failing to protect your assets from creditors, predators, bankruptcy, divorce, family issues. I mean, there's so many different things with a trust, as you mentioned, that you can do to help during your lifetime protect against such things, but also when you're gone are going to keep a lot of bad things from happening.
Yeah, absolutely. One of the things that people don't think about is if they might want everything to go to their kids equally, but not all those kids are equally responsible. And it's not uncommon to have a child, an adult child, who's either going through a bad divorce or going through a bankruptcy or had other issues. Maybe they've got some health issues or mental issues. And the last thing you need is for their inheritance to go straight into their hands. They may end up losing it as part of whatever's going on. Or it may be something that enables them to turn around and go off the deep end, maybe, if they're dealing with an addictive issue.
There you go. So you can set up parameters within a trust, for instance, to put certain limits, that is, as far as basically ways to protect your beneficiaries. We'll get into that a little more. First, we're going to take a break. Join us here. We'll be right back on the Retirement Report.